Good morning, everyone. Thanks for coming to our Thursday webinar for the Homeowners Associations and the Law. My name is Zach Passmore, and I'm an enforcement attorney here at the department. But today I'm here to discuss with y'all the Homeowners Associations and the Law presentation regarding the state laws for HOAs and horizontal property regimes. Of course, the standard legal disclaimer that this presentation is not meant to serve as a substitute for reading the various laws that I'm going to cover today or requesting a legal opinion from a private attorney or seeking additional legal remedies. We're providing this presentation today for educational purposes and to serve as an introduction into the HOA laws. So, with that out of the way, let's talk about some South Carolina laws that may apply to a homeowners association. The big question is, how does an HOA know what they can and cannot do? There's generally two buckets of information that a homeowners association can look to. The first one being applicable laws. In South Carolina, there are 3 different laws that may or may not cover an HOA depending on how they're set up. First one being the South Carolina Nonprofit Corporation Act. That applies to specifically registered nonprofit organized HOAs. We have the South Carolina Horizontal Property Act that covers horizontal property regimes. And we have the South Carolina Homeowners Association Act. These different bodies of law go into different levels of detail as to what a homeowners association must do, again, depending on how they're set up. Now, the second body that we look to is the HOA governing documents, and these are typically including the HOA's declaration, the master deeds, and their bylaws. These cover the rights and responsibilities of members in the HOA, but they typically set out how the homeowners association will operate. This includes information on meetings, dues, special assessments, elections, and collection policies. Certain provisions in the rules and other governing documents may be superseded by state law, which I'll go into in a minute. But as far as rules and regulations, these are commonly referred to as covenants, conditions, and restrictions, or CC&Rs. They limit how a homeowner can improve or use their property. The topics that are often covered in these rules are related to landscaping, home and building standards, guests, and pets. So the law requires that governing documents are to be filed and provide certain meeting notice requirements and access to budget and membership lists for the members. The law also requires that our department collect specific data on HOA complaints and report such data. So the first one that I'll go into today is the South Carolina Homeowners Association Act. This one is, I would say, the least detailed as far as what the act requires of homeowners associations. And I will note at the outset that there is some confusion as to this particular statute. Starting in the early 2000s, there were several HOA bills that were introduced in the legislature, and they took many different forms. Some of them dealt solely with governing documents, while some of them also dealt with preventing certain restrictions on homeowners' rights who lived in an HOA. But only the only one of them that has passed, and which gave a more comprehensive set of rules governing an HOA, was the South Carolina Homeowners Association Act. It was passed in 2018 and was amended heavily while going through the legislative process. The confusion occurs because all the previous iterations of the bills that did not pass can be found online and may show up when someone is searching for HOA laws. So it's important to note that the act that I am going to discuss today, this is the law that was passed, and that others that did not, which may be found online, those are not law and they have not been implemented. So going into the act that has been implemented and is law in our state is the South Carolina Homeowners Association Act, which defines a homeowners association as an entity developed to manage and maintain a planned community or horizontal property regime for which there is a declaration requiring an owner to pay assessments for a share of real estate taxes, insurance premiums, maintenance or improvement of or services or other expenses related to common elements and other real estate described in that declaration. So by virtue of this ownership of a separate property within the planned community or horizontal property regime, so if it's set up for these purposes, that is what a homeowner association is. This definition excludes a vacation time sharing plan. There is a separate body of law that covers those setups. So under the Homeowners Association Act, there is a filing requirement for governing documents, rules, regulations, and amendments. Any governing documents existing before the Act became effective on May 17, 2018, must have been recorded in the county where the association is located by January 10, 2019 in order to be enforceable. So governing documents, of course, include the HOA declaration, master deeds, and bylaws. Any new or amended governing documents, rules, and regulations must also be filed in the county by January 10th of each year following the adoption or amendment. Where would that be filed? It varies by county. Typically, you would find that these are filed at the county clerk of court or the register of lien conveyance or possibly the register of deeds. You would look to where the property is located to determine where exactly these governing documents would need to be filed. So under this act, homeowners do have access to certain documents, including the rules, regulations, and amendments. So the HOAs must make rules, regulations, and their amendments available upon request, unless the HOA has already posted them in a conspicuous place in a common area within the community, or maintain a web page where members can download these documents. Now, the type of documents that members have access to are the budget and the membership lists. All HOAs are subject to certain access to document requirements in the South Carolina Non-Corporation Act as well, which I'll talk about later. But the purpose of this access is for homeowners to inspect and copy the association's budget and membership lists. Now, the venue for enforcement of this act is circuit court. So if you're in a situation where you have requested these kinds of documents and the HOA has not made them available to you, your enforcement mechanism under the Homeowners Association Act would be to go to court. So in that scenario, you'd want to talk to a private attorney to consider your legal options. Of course, you could also file a complaint with our department for our voluntary mediation services, which I'll touch on a little later in this presentation. Now, under the Association Act, there is a meeting notice requirement, a very narrow one. Associations other than nonprofit corporations must provide homeowners notice 48 hours in advance of the meeting in which a decision to raise the annual budget is made. That is the only provision in this act that has a meeting notice requirement. It's for when there is a meeting to increase the annual budget. The notice may be posted in a common area in the community on the HOA's website. It could be sent by email or by any other method that is described in the HOA's bylaw. It's important to note that this requirement also applies only to associations other than nonprofit corporations, because there are certain provisions in the Nonprofit Corporations Act that will apply to HOAs who have chosen to become nonprofit corporations. And as I said, it's a narrow notice requirement for raising the annual budget. The Association Act also establishes a disclosure for home buyers. A seller must let a purchaser know if the property is part of a homeowners association, and this is done through what's called the South Carolina Residential Property Disclosure Statement. It's a uniform disclosure statement that can be found on the Department of Labor Licensing and Regulations website at llr.sc.gov if you want to take a look at a template of that disclosure statement. If you are thinking of purchasing a home, the department recommends that some of the first steps that you take is to get a copy of the governing documents of the HOA if there is one. You can also request association meeting minutes from the past 12 months and any newsletters sent out during that time. Another thing you may want to do is ask for something in writing from the homeowners association stating that the home is not currently in violation of any of the association's rules. Another thing that you might want to consider is attending an association meeting to talk to neighbors to see how well the association functions. You can also do things such as a simple internet search for any online complaints or lawsuits related to the association. The reason why we recommend that you do take some of these steps to research the homeowners association if you are a prospective home buyer is because it's very important to do your research up front, because once you're in, you're in. You're subject to the HOA's authority and you're responsible to comply with their adopted rules and regulations. You may not have been there when they were adopted, but once you were in, you were bound by them. Now, the Homeowners Association Act establishes the Magistrates Court as the venue to hear monetary disputes involving a homeowners association if the amount in issue does not exceed $7,500. The Act also sets up the complaint processing and reporting at our department for consumer complaints regarding homeowners associations. The Department of Consumer Affairs is to take and collect specific data on the HOA complaints that we receive and compile and share this data with the governor and the General Assembly each year. So to kind of go into a little more detail as to that. So as I said, what our department does is that we do take HOA complaints. Before the Homeowners Association Act was implemented, our department regularly received HOA complaints as we would receive complaints against any other type of business. But what the law changed was that now we have to take and collect certain data that is described in the Act. HOA complaints nowadays have a specific supplemental form that includes the information that we are to disclose to the General Assembly and the Governor's office. So if we do not receive a complaint with that supplement filled out, we will be unable to process the HOA complaint. As I said, we compile this data found in the supplemental form, and we share it annually with the Governor and the General Assembly so they can see any trends in the HOA space that may be occurring and may require a law change. We also provide education, like we're doing today, to homeowners and HOAs regarding the Homeowners Association Act and other laws. Some things that we do not do in the HOA space: we do not administer the Homeowners Association Act, nor can we enforce the HOA Act. The Act specifically says that our department does not have the authority to arbitrate any HOA complaints. Therefore, we cannot enforce a homeowners association to provide a particular resolution to a complaint, nor can we even require that they respond to the complaint. We are here to hopefully assist with resolution of issues that homeowners have with HOAs through our voluntary mediation process. And as I said, collect specific data to go to the Governor and the General Assembly. So of course, if you would like assistance from the Department of Consumer Affairs with your HOA issue, you can file a complaint on our website, consumer.sc.gov. And on the website, there is a specific tab on the complaints page with the Homeowners Association supplemental form that you can attach to your complaint. So let's look at a couple of scenarios as to how you can work through the Homeowners Association Act and how it is implemented. So the first scenario If the bylaws and the covenants on file are older than 2018, are they still valid? The answer to this is yes. If a governing document was recorded prior to May 17th, 2018, it is effective. And amendments to governing documents must be filed by January 10th of the year following their adoption. So with governing documents, if they were not filed before May 17th, 2018, they would have needed to be recorded by January 10th, 2019 in order to continue to be enforceable. Of course, as a reminder, the governing documents include the HOA declaration, the master deeds, and the bylaws. And amendments should be filed, again, by January 10th of each year. And that would be including new governing documents would need to be filed by January 10th, the year following their adoptions. And rules and regulations are meant to be filed as well by January 10th, the year following their adoption. So a second scenario, if the rules and regulations are amended, when can they be enforced and put into practice? They are effective when they are passed or adopted. So after the meeting where they are put in place, they are passed or adopted and they are effective. However, amendments to the rules and regulations must be filed by January 10th, the year following their adoption in order to remain effective and enforceable. So that is kind of a broad overview of the South Carolina Homeowners Association Act. As I said, it is the most, or I guess I should say, it is the less detailed of the three acts that we have here. So moving up a step in detail and requirements for homeowner associations is the South Carolina Nonprofit Corporation Act. So one thing you might have noticed about the Homeowners Association Act that I just discussed is that there is no filing requirement for an HOA to let any agency in the state or our department know that they exist. The only thing that they have to do is to file their governing documents with the appropriate entity in their county. However, if an HOA chooses to become a nonprofit corporation, they do have to file its articles of incorporation with the Secretary of State. So you can use the business filing search on the Secretary of State's website to see if a particular HOA is registered as a nonprofit corporation. But it is important to note that in some very limited provisions, and per the Homeowners Association Act, there are certain provisions of this Nonprofit Corporation Act that also apply to HOAs that are not registered as nonprofits. So under the Nonprofit Corporation Act, a nonprofit corporation must have a board of directors or someone named in the articles who has the powers that are normally held by a board of directors. A board of directors must be made up of 3 or more people elected by members or appointed through the laws or through the bylaws, and they have a term of 5 years or less. Unless otherwise provided for in the articles or the bylaws, a corporation must have a president, a secretary, and a treasurer. And 1 officer must take minutes at directors and members' meetings. As far as membership, the articles or bylaws must set out how someone becomes a member of the corporation. And unless the act or articles or bylaws say otherwise, each member is entitled to 1 vote. A quorum is 10% of the votes entitled to be cast, and proxies are allowed. Now, under this act, as far as access to documents, the law requires nonprofit corporations to keep certain items, including minutes of directors and members' meetings, including committees of the board, articles and any current amendments, names and addresses of its current directors and officers, Any written communications made to members within the past 3 years, including financial statements, records of all actions approved by the members for the past 3 years, and copies of any reports filed with the Secretary of State. Members of the HOA under this act have a right to inspect and copy records held by the corporation. Now, as far as meeting requirements, including the types of meetings, the notice required, and voting, as you can see, it's a little more detailed than what the Homeowners Association Act requires. Nonprofit corporations must have an annual meeting each year where the president and the chief financial officer report on activities and the financial condition of the corporation. Meeting notice given to members must be fair and reasonable. The place, date, and time of each annual, regular, and special meeting must be given at least 10 days ahead of time, but no sooner than 60 days before the meeting. If that's followed, then it is considered fair and reasonable. Any matter the members must approve if an annual or regular meeting, or if a special called meeting, a description of what will be discussed and issues a member intends to raise during the meeting, if certain requirements are met. So if the corporation notifies members of these following things, then the notice is considered fair and reasonable. So our first scenario under the Nonprofit Corporation Act, let's assume that an HOA member is asking for access to meeting minutes from 5 years ago. Does the HOA have to provide them? Well, if they are a nonprofit, yes. A nonprofit HOA must comply with the Nonprofit Corporation Act in its entirety, which includes Section 33-31-1601, which requires that meeting minutes be kept in perpetuity. And 1602 requires that records be open for inspection upon written notice or demand from a member. So to kind of go into a little more detail, the things that are required to be kept, of course, again, are meetings or minutes of all meetings of its members and board of directors, a record of all actions taken by the members or directors without a meeting, and a record of all actions taken by committees of the board of directors as authorized. So if the HOA is a nonprofit, it changes a little bit to maybe. And in that case, it would depend on what the HOA's recorded bylaws say regarding their record maintenance and retention. If for some reason the HOA doesn't comply with a valid request for records, then under this act, the homeowner goes to circuit court for enforcement. In our second scenario, an HOA member is asking for access to invoices. Does the HOA have to provide them? Again, if it's a nonprofit corporation, yes. kind of for the same reason as the meeting minutes. HOA must comply with the Nonprofit Corporation Act in its entirety. Section 1601 requires, in addition to meeting minutes, appropriate accounting records be maintained. And 1602 requires that those records be open for inspection upon written demand or notice of a member. If they're not a nonprofit, again, the answer is maybe. For the same reason, it would depend on what the HOA bylaws say about access to the records. So as you can see, the Nonprofit Corporation Act is a bit more detailed as far as to retention requirements and requests for documents from members. One question we've gotten previously is, what about attorney invoices for attorneys that the HOA employs? In which case, we can scrap those, because the answer is a standard lawyer one, in that it depends. It's a complex issue regarding attorneys' invoices. Some could take the position that there are attorney-client privilege concerns there. So there really is no cut and dry answer as to attorney invoices. It's an especially complex question to answer since our department does not enforce the Nonprofit Corporation Act. It's a murky situation because while homeowner is a member of the Homeowners Association Act, that attorney is not necessarily specifically representing that member. So that's where attorney-client privilege concerns may come in, which is kind of the preamble for me to say that in this scenario, you would need to seek the assistance of private legal counsel. So in our third scenario, the consumer would like to contact a member of the board of the Homeowners Association. They've asked the HOA for the contact information of the board member. Can the HOA refuse to provide the board member's contact info? If the HOA is a nonprofit, the answer is no. Because again, it must comply with the Nonprofit Corporation Act in its entirety. 1602, among the other things that we've discussed, requires that records be open for inspection upon written demand or notice of a member, which under 1601 includes a list of name and business or home addresses of its current directors or offices. If it's a nonprofit, the answer is most likely no. I put the asterisk there because it kind of shows how the two acts work together. Because as I said previously, there are certain parts of the Nonprofit Corporation Act that apply to HOAs in addition to nonprofit corporations. This is one of those scenarios. So Section 27 of the Homeowners Association Act, or Section 3150 rather, of the Homeowners Association Act requires all HOAs, nonprofit or not, to comply with certain provisions of the Nonprofit Corporation Act. Now, while the HOA Act does not specifically reference 33, 31, 1601, it does include 33, 31, 1602, which is that records be open for an inspection upon written demand or notice. And it also includes 1605, which is a limitation on the use of the members list for purposes of permitting access to the budget and homeowners membership lists. So I guess at a minimum, the HOA would at least have to permit access to the membership list, which would likely have board members' information on it. But again, that may be a question for a private attorney if you're looking to go into any specific detail into it. Although it's important to note that the way that a member requests this type of information is through written notice or written demand at least 5 business days before the date on which the member wishes to inspect and copy the records. So that covers the South Carolina Nonprofit Corporation Act. And now I will move into the most detailed act governing these types of associations, the South Carolina Horizontal Property Act. This act covers horizontal property regimes, which are usually set up in apartment complexes or condominiums. Like I said, the governing of these regimes is even more specific than the Nonprofit Corporations Act and the HOA Act. So in setting up a horizontal property regime, the filing requirements are that lessees or owners must draft a master deed or lease stating that they want to create the regime. And they must attach any bylaws, plot plan, or building plan. They must record it with the appropriate agency in their county, which, as I've said previously, would be the Register of Deeds or the Clerk of Court or the Register of Mean Conveyance. The master deed must include several things, including a description of the land and buildings, general description of each apartment, a description of common elements and restricted common elements, a value of the property in each apartment, along with the percentage of rights to common elements. the name of the regime, which must be followed by the words horizontal property regime. And it must include a description of legal rights and obligations of apartment owners, the co-owners, and the person establishing the regime. Now, if the development is being planned in multiple stages, there are additional items that are required. And in general, there are a few more things that are required under this section of the Act. So it's important to bear in mind that this is not a substitute for reviewing the actual statute, and these are highlights. Now, as far as the bylaws go, bylaws must include whether the regime will be run by an administrator or a board or some other method. And it must include the powers, the manner of removal of that administration, and the compensation for the persons. It must also include information on the method of calling a meeting of the owners, who will preside over those meetings and who will take the minutes. As far as voting goes, the horizontal property requires bylaws include that majority of at least 51% is required to adopt decisions. So unlike the other laws that we've talked about so far today, you'll see that this act goes furthest and requires that certain things are included in a regime's bylaws. That's not necessarily the case under the Nonprofit Corporation Act or the HOA Act. Additionally, bylaws must include information on the common elements and the services provided, which include things like description of the care, upkeep, and surveillance of property and common expenses, designation and dismissal of personnel necessary to provide common services. The bylaws also must include a description of the manner of payments that will be collected from the owners. As far as expenses, record keeping, and access to records, owners must contribute a pro rata share toward expenses of the administration, maintenance and repair of the common elements, repair of limited common elements that insurance doesn't cover, such as repairs, reconstruction of common elements shared by a few owners, and any other item or service agreed to. The regime administrator must also keep detailed records of receipts and expenditures, and owners have a right to inspect these books and vouchers in a manner prescribed by the Act. So as far as pro rata share goes, that is laid out in the Act itself. Also, any assessments left unpaid at the time of an apartment sale will be taken out of the sale price. There are general apartment owner property rights outlined in the Horizontal Property Act. An apartment owner has the right to exclusive ownership of their apartment and the right to use common elements so long as that the use does not hinder the rights of other owners. Common elements under the Act include things such as elevators, garbage incinerators, basements, flat roofs, gardens, main walls, roofs, halls, lobbies, and stairways. Limited common elements are those common elements that owners agree are reserved for the use of specific owners. So under the bylaws, there are certain elements that the parties can agree that certain things are reserved for certain owners. The Act also includes other provisions for things such as repairs, insuring the property, how to dismantle the regime, and a litany of other things. So for our first example as to how the Horizontal Property Regime Act, or Horizontal Property Act goes, I live in an HPR. Is it true that when the unit above me has a water leak that damages my unit, I am responsible to fix it via my insurance? The answer here is that it depends. And the first thing that you would do is to look to the master deed or the lease, because it must describe the full rights and obligations of an apartment owner, the co-owners, and the person establishing the regime. The description, or the master deed or lease must also include a description of the general common elements and any limited common elements. And as I said earlier, this includes several things such as main walls, roofs, compartments, or installations of central services such as power, light, gas, cold and hot water, refrigeration, reservoirs, water tanks, and pumps. So as you can see, the question is multifaceted. It may depend on your certain issues, such as whether the leak occurs in one of the common elements that you have access to. Another question that would need to be looked into to get a definitive answer on this is, what was the cause of the leak? Was it caused by some essential service that's being provided to the property as a whole, or was it caused by some other owner? So the way that a horizontal property regime works is that both owners of the properties insure the property through the regime, but they also carry their own homeowners insurance. So again, it really depends on the specific circumstances of the damage and what the master deed or lease says regarding owner responsibilities and co-rights. It is possible that insurance will be paid out through the regime, since the law requires that processes be created for insuring of the general common elements. But big picture for this question is, first look to the master deed or the lease. So now that we've gone over at broad strokes of the 3 acts that cover HOAs in South Carolina, we also have some tips for dealing with HOA issues. Again, there is no state agency that enforces or administers these laws, and our department specifically does not have regulatory authority over them. So what can a homeowner do when they have HOA issues? The first thing that we would recommend is to try talking with your HOA's board of directors and be prepared for this discussion. By being prepared, I mean looking to your HOA's rules and regulations, CCNRs, or governing documents to see what it says about the issue that you are dealing with. And you would want to check your governing documents to see if a formal dispute process is included. If this doesn't work, of course, you can work to elect members that you think will be more responsive to your needs. Or, of course, you can run for election yourself. So work through the process to hopefully get a resolution to your specific issue. Of course, if your issue involves a monetary dispute, magistrate's court can always be an option. This link here has general FAQs for magistrate's court, including how to file certain HOA type claims. An attorney is not necessarily needed when filing an action in magistrate's court, but of course, I would always recommend that people speak to a private attorney regardless. Going down that route, you can also seek legal advice from an attorney, as I just said. If you do need help finding an attorney that is competent in HOA issues, we recommend the South Carolina Bar Association's lawyer referral service at the number on the screen or the website link there. They maintain a roster of attorneys on various legal subjects that have agreed to discussing or initial consultations at a reduced rate. You may be able to find an HOA attorney there. Of course, you can also file a complaint with our department, as I've said earlier, so that we can attempt to assist in resolving your HOA issue through our voluntary mediation. As I said, we can't require that an HOA provide a specific outcome for a consumer's complaint, but we are there to kind of keep the line of communication open and hopefully assist with finding a resolution to the issue. And of course, if you are looking for changes in the HOA laws, you can contact your legislature, which can be found at scstatehouse.gov, all sorts of contact information for your state level legislator. Also, you can go to this website to quick search any bills that are in the pipeline regarding HOAs or any past bills that have been enacted into law. And there at the bottom left of the screen, you can find out who your legislators are and their contact information. So with regard to legislation, there is some pending legislation out there between the House of Representatives and the Senate regarding homeowners associations. Before I start kind of going through them, it's important to remember that these are bills, and as of today, as of the time of this presentation, none of these bills have been adopted and therefore have no legal enforceability or authority. They will not have any kind of enforceability until they are passed and become law. But as far as pending legislation goes, there are a few things such as H3090, which would enact the revised Uniform Unincorporated Nonprofit Association Act. This is a model set of laws that 17 other states have adopted. It establishes that a nonprofit association is a legal entity distinct from its members and managers and affords the nonprofit association the same powers as an individual to do all the things necessary or convenient to carry on its purpose. It also imposes some liability limitations on members and managers and relaxes some formalities regarding a nonprofit corporation's exercise of powers. H3180 would prohibit an HOA's authority to foreclose property, to collect unpaid dues, fees, or fines. This one has been referred to the Committee on Labor, Commerce, and Industry. As far as H3259, that would require HOAs to send copies of annual operating budget and operating expenses to homeowners and submit them to our department as well. Again, this one has been referred to the Committee on Labor, Commerce, and Industry. House Bill 3568 would require that HOAs, before spending funds not within the approved budget, to provide 48-hour notice of a special meeting with a quorum present to approve that expenditure. There's also a couple of acts out there that would protect a homeowner's or tenant's display of political signs, but allowing HOAs to establish certain rules regarding the display of those signs. And also 3775 there, HOAs would not be able to restrict a homeowner from flying an American flag on a flagpole on their property. That one's been referred to the Committee on the Judiciary. Now on the Senate side, there's a couple of bills out there. Senate Bill 118 would require HOAs to provide a statement of unpaid assessments or other charges to the homeowner upon request. That's been sent to the Senate's Committee on Judiciary. Senate Bill 421 would state that HOAs cannot prohibit homeowners from peacefully assembling, organizing speaking events, canvassing, or circulating materials. And Bill 422 would say that HOAs cannot prohibit the installation of solar panels that cannot be seen from the street or common areas surrounding a residence. And I'll say one more time that these are all bills and are not yet enforceable law. They may in the future become law, but as of right now, we don't know. Now, our department does provide several resources for homeowners regarding HOAs. As I've said a few times now, you can file a complaint with our department so that we may assist through our voluntary mediation services. If you click on the complaints link on our homepage, you'll see on the complaints page that there's a specific section where you file an HOA complaint, that it would include the supplemental form that is required to be filled out for an HOA complaint. And you can file this either online in our online complaint portal, or we can also take paper complaints as well. You can mail them to us, drop them off at our office. We do have a link down there at the bottom so that you can either file online or download a hard copy, or you could download the complaint form so that you can submit a hard copy. As I said, for HOA complaints, there is a required supplemental questionnaire. So if you are filing an HOA complaint without this questionnaire, we are unable to process it. We do encourage you to file this. We do encourage you in general to file your complaints online. The reason why we do so is because consumers can create user accounts, which can be used for more than one complaint. Online filing has an increased methods of contact. Consumers will be able to email directly the complaint analyst that is assigned to their complaint. They're also able to submit comments or provide updates through the system regarding their complaint. Consumers are also able to upload any supporting documentation to their complaint at the time of filing. As I said, one of those things that would need to be uploaded would be the supplemental questionnaire. But of course, if you do not want to file online, we can also take the complaint through the mail at the address on the screen here. And if you are filing online, this is what the Homeowners Association questionnaire would look like. We also have an education page set up specifically for consumers regarding HOAs. It's under the Consumer Resources tab on our homepage and then under HOA Education. If you go to this page, you will see links to the 3 laws that I have discussed today. You can review the laws in their entirety on your own. It also includes the HOA report that we are required to submit to the legislature, including our 5-year report that would also be on this page. So the report is a compilation of data from the first 5 reports that we issued. The department issued the first annual report on January 31st, 2019, which contained information compiled from complaints received from June 1st, 2018 to December 31st, 2018. Every report issued thereafter contains data from the prior calendar year. With regards to the 5-year report, the 5 reports issued during that time only included 1,012 complaints, as 170 did not meet the statutory requirement for inclusion, such as a complaint that did not include the required supplemental questionnaire, or they were duplicates, or they were referred for other reasons to the South Carolina Human Affairs Commission. In the 4.5 years prior to the law going into effect, Department of Consumer Affairs has received 167 HOA complaints. So that was prior to the law going into effect. We certainly get more nowadays. And of course, this page also has relevant contacts that you may need with regards to seeking assistance to any HOA complaint you might have. Our department also produces some helpful guides regarding the 3 acts that I've discussed today, as well as frequently asked questions about the Homeowner Association. I believe the FAQ is linked to this webinar, but any other documents that we produce regarding HOAs you can find on our website. Our department also maintains a YouTube channel, SCDCA TV, which has archived webinars on all sorts of issues, including HOAs. You can go to the playlist tab and you can see that as of right now, we have 7 videos regarding HOA issues. So you can review these at your leisure. And the topics discussed are Homeowner Association law, like I've discussed today, as well as our 5-year complaint report and some videos on some certain specific issues. So at this time, if anyone has any questions, I will attempt to answer them. I would like to bear in mind that I can't answer any specific legal questions that you may have pertaining to HOAs. So in that case, I would strongly suggest you talk to a private attorney to assist you with those. But we did have a couple of questions submitted before this webinar that I believe are worth going over. So feel free to put in any questions that you may have while I discuss them. But one of the questions that we received was, can an HOA retaliate against a member who files a complaint with a DCA? Well, that question I would recommend speaking to a private attorney. The reason why I would do that is because that you would first need to determine whether or not such conduct could be linked to any kind of retaliation. It's also important to look to the governing documents and the rules and regulations of the HOA, because again, that kind of governs how these organizations are operating and how they are supposed, and the processes in which they are supposed to implement. So if they are following their bylaws, that's what's required in their governing documents. That's what is required as well. But if you were to suspect that it is effectively in retaliation for any kind of complaint filed with our department, then I would suggest speaking to a private attorney to consider any legal remedy that you may have available to you. Another question we received is, how does South Carolina law protect the voting rights of minority HOA members? Now, it is important, as I've discussed earlier, there are some voting procedures outlined in the South Carolina Nonprofit Corporation Act, but it's important to remember that that act does not apply to every type of homeowners association in the state. So my answer, and honestly the answer is going to be common, but the answer is to look towards the governing documents of the HOA. So you'd want to look to those to see what the voting rights are outlined as far as membership, voting rights, membership, voting classes, things of that nature. And of course, as I'll probably say a few more times, talk to a private attorney regarding any specific issues you may be having or questions you may have regarding voting. Another interesting question that we got up front was kind of broadly whether homeowner associations can enact any rules regarding service animals or therapy animals. It's a good question, but it's outside the scope of the homeowners association laws that I've discussed today. There may be some federal law coverage with regards to certified service animals and things like that, in which case that might be a question for the Human Affairs Commission here in South Carolina. And of course, my popular refrain, it could also be a question for a private attorney. But those were the questions that I received ahead of time. Scott, our communications director, is on the line with us. Scott, have any other questions been submitted?
Yeah, we have one from somebody who says when they purchased their HOA, they allowed short-term rentals, and they've since changed the rules to ban them. And they're asking, I'm trying to paraphrase, but they're asking, shouldn't they be grandfathered in since those were the rules at the time of purchase?
Well, first thing would be to look at the rules that are filed with the Register of Deeds or the appropriate office in the county. If you remember, under the HOA Act, amendments to the rules need to be filed by January 10th of the following year in order to remain in effect. So that would be my answer, is to check the rules, make sure that they've been properly recorded, because that's what would be governing on that question.
There was somebody else who asked kind of when, it's a horizontal property, and which law would take precedent in that case, the Homeowners Association Act or the Horizontal Property Act?
It would be the horizontal property regime, or sorry, the Horizontal Property Act, if it is in fact an organized horizontal property regime. As I said when I was going through that act, there are several things that need to be recorded if it is in fact a horizontal property regime. So if it is a horizontal property regime, then it would be the Horizontal Property Act that would take precedence. Of course, since these are overlapping laws, it's also worth possibly talking to a private attorney to see if there is any kind of overlap.
And somebody's asked, for HOAs owned by developers, how is ownership transferred to homeowners once the development is complete? That is
usually outlined in the PUD, which I was just talking about this morning, and I'm blanking right now on what that stands for. But typically, when a planned development is created, they typically start out with that information as to when ownership transfers over to the members. It's typically triggered by either a certain percentage of properties that are sold, or at a certain date or volume of property owners. So I guess the answer is it depends, but it's typically outlaid in that initial PUD.
We had somebody who asked about the budget for their HOA. They said they're good at publishing the budget at the beginning of the year, but does not give updates. And when they have a meeting, the spending is a big surprise. What can they do?
Well, again, that depends on if it's, or I guess how the HOA is set up. Because remember, it's depending on how it's set up, a different body of law may apply. If it's a nonprofit corporation, there are some more requirements as far as meetings and documents that can be requested. I would suggest that they take a look at the Nonprofit Corporation Act and see how they can make their request to inspect these documents. But also remember, in the Homeowners Association Act, it's less detailed as to what is required to be provided. So that's kind of why I'm saying it depends on how the HOA is set up. So I would definitely recommend reviewing the governing documents of the HOA to determine how it's set up, and then the two different acts to make sure that the process is being followed correctly.
We had somebody ask about kind of membership classes in the HOA, that if they can legally give some members 2 votes on an issue while others get 1 vote or no votes on the issue.
Well, the answer to that is actually kind of similar to my last answer, in that it depends on how the Homeowners Association is set up. Again, the Nonprofit Corporation Act does have some certain criteria with regard to voting and the allocation of voting power. But if it's a homeowners association, again, that is under if it's not a nonprofit and it falls under the Homeowners Association Act, again, it is less restrictive as far as how voting procedures are set up. And in that case, you would have to look to the governing documents of the HOA and the bylaws, things of that nature, to determine the proper voting procedure.
We do have somebody that says they've asked for months to attend a board meeting and keep getting a response from the management company that they have not received confirmation yet. They're kind of asking what they can do.
In that case, I would recommend speaking to a private attorney to see if there are any kind of legal remedies available, because if there is some sort of, after consultation with the attorney, if there is some sort of violation or identified deficiency in the HOA following the Nonprofit Corporation Act, the Horizontal Property Act, or the HOA Act, circuit court would be the avenue to address those legal claims. I'll also take this time to encourage you to connect with us on social media. We have social media presence on several venues, including Facebook, X, formerly Twitter. I believe we're on Nextdoor as well. And as we've said a few times, we maintain a YouTube channel with videos on all sorts of consumer issues. And we also publish a whole bunch of documents on consumer issues, including ID theft, credit reports. We have a car buyer's guide. There's all sorts of stuff available on our website, or you can reach out to us and we can mail you some hard copies. That is all I have today. If anyone does have any questions, like I said, please email us at our general inbox and we will get back to you when we can. But other than that, I hope everyone else has a good rest of their day, and we will see you next time.